Welcome once again to Lehto's Law. Here's Steve Lehto.
Sean sent me notes that Steve, you checked out the most recent issue of National Hog Farmer. And I said, it's in my reading pile. Haven't gotten to it yet. Why? What's happening in National Hog Farmer? Well, Ann Hess wrote an article. Hormel files lawsuit alleging that a former staff member leaked sausage-making secrets to Johnsonville. And so we're going to have a big old battle in this industry involving trade secrets and how sausage is made. So meat processor says improper use of proprietary information or wrongful solicitation could put a manufacturer at a significant competitive economic disadvantage. So Hormel has filed a lawsuit against Johnsonville and two former employees, claiming the defendants violated the law by interfering with Hormel's employment relationships and unlawfully obtaining Hormel's trade secrets on sausage production. In a complaint filed recently in Minnesota District Court, Hormel claims that when two former directors of operations joined Johnsonville, they violated legal obligations to their former employer. Hormel contends that because one of them agreed to provide a copy of his proprietary information, non-compete, non-solicitation, and invention assignment agreement to any potential employer, Johnsonville knew or should have known of his non-solicitation obligations. According to the agreement, the man agreed that he would not solicit Hormel employees for a period of 1 year after his termination, and agreed further that the 1 year period would be tolled for any period of non-compliance. However, Hormel claims that man immediately began to solicit Hormel employees upon his hire at Johnsonville, and that the other man admitted to Hormel that the solicitation by the first man, while an agent of Johnsonville, led to his employment there. So follow along. There's two companies, okay? And the first company, has got a bunch of employees working for it who are in high positions, and they are exposed to trade secrets or proprietary information. And so this company makes these employees sign an agreement. This is part of your employment agreement with us, is that you're gonna protect our trade secrets. And if you leave here, you're not going to start poaching employees from here when you leave. And you're also not going to, expose our trade secrets to other competitors. You're not going to do that either. They say that one guy left, and after he left, he then solicited guys from the first place, which they say violates that agreement, okay? Now, Hormel also alleges that after accepting employment with Johnsonville, but before informing Hormel of his intent to resign, he used his Hormel email account to send highly confidential, proprietary, and trade secret information to his personal email account. The company contends the information he sent to his personal email included product formulas, processing procedures, acquisition target information, and marketing strategies, as well as significant information related to Hormel's sausage manufacturing process and products. So Hormel says that they conducted forensic imaging of the man's phone and email, and then they fired him in May due to his material breach of the agreement and code of ethical business conduct. The same day, Hormel sent a letter to Johnsonville outlining the violations by these two men and asking for a number of assurances from Johnsonville. And they say that Johnsonville refused to adequately provide the assurances reasonably requested. So this is going to be a fight in court. We'll see what happens. Hormel has requested a jury trial, and they're also asking for proprietary information to be returned to the company. And presumably, the question really is, if they got the information and they know what it is, to simply return it won't solve the problem because, Xerox machines do exist, figuratively speaking. Nowadays, you can just cut and paste, but the cat's out of the bag. But one of the interesting things is I've heard of companies before that have people in positions of power and authority, and these people have access to all kinds of trade secrets and proprietary information, and then they leave and go work for a competitor. And so, as you can imagine, if you are a wise company, you have in place procedures where you say, before we give you access to all our proprietary information, you're going to sign a document and you are going to promise that you will never reveal anything we show you, and you're not going to take it when you leave, And you're also, and this is another important one, also, if you develop something while you are here, while we're paying you to develop things, that becomes a trade secret. Because I've had people tell me, they say, well, Steve, I can understand that I won't steal trade secrets that are shown to me. But what if I develop it myself while I work here? Oh, most of these agreements say that if you're working for us and we're paying you to develop something, that's ours, not yours. And so the best example I can think of is I've written books about the Dodge Daytona, the wing car, as well as the Superbird, and also Chrysler Turbine car. And there are a lot of patents involved with both of those vehicles. And I've seen those patents. And the patents will often list the inventor as the person who invented it. And then right below it will say assigned to Chrysler Corporation. Because while working for Chrysler, some guy develops a bunch of stuff for the turbine car. When they apply for the patents, they put his name on it as a courtesy because he's the one who invented it. But the patent belongs to Chrysler because they were paying his bill the entire time, salary while he was developing that. And that becomes something that's the property of Chrysler because they're his employer at the time. So if you're working for Hormel and you develop the process, or someone shows you, here is our secret sausage making process, that's something you've learned as part of your job. And if you sign an agreement saying you won't reveal it to anybody, well, it does create a sticky situation if you go work for a competitor. Now, I'm kind of surprised, but I did see this big, long description here. Non-compete, non-solicitation, and invention assignment agreement. It starts off with non-compete. And so the question is, if the guy simply went from one company to the other, does non-compete allow him to do that? Or was there a time frame or a regional frame? Because one of the things I've talked about before is non-competes. I have a lot of people tell me they've signed one, and then later on they're like, I don't think they're enforceable. And it depends on the state you're in. But most states allow non-competes on some level. It's a question of to what degree they'll enforce them. And it depends pretty much usually on how long are they or what do they cover in terms of geography. So let's suppose that you went to work for a company that made widgets. And there are widget manufacturers scattered across the globe. And you come to work for me and I say, hey, I want you to become my new widget maker. I need widget makers. But we've got some proprietary information. We make very, very special widgets. And you say, I want to work for you. I say, great. Sign this non-compete. And you go, what does that mean? And it says here that if you work for me, you cannot leave and go into a competing business within 100 miles of me for 5 years. And you look at a map and you go, it's not that bad. Okay. So you work for me for a little while. And then the widget manufacturer right down the street, within 100 miles, contacts you and says, hey, why don't you come work for us? We like those widgets you make. You go, oh, okay. So you go work for them. And I find out about this when you quit and you pop up over there making widgets. And I say, well, you're within 100 miles because the street ain't that long. I said, down the street. And it's within 5 years. Can't do that. So now you want to keep that job, and I'm not going to hire you back. So we go to court. And in court, the judge is, what's going on? We tell him, or her. And you say, Your Honor, this is inherently unfair. And the judge would say, well, first of all, you signed it. You're an adult. You weren't under duress when you signed it, were you? Second of all, 100 miles for 5 years. That means that 5 years and a day from now, you can go work at this place. Or just go 100 miles out. There's other widget manufacturers out there. Choose one of them. But what almost always happens with the cases we see is that there have been unreasonable limitations put in there. You can't work for anybody in the universe forever making widgets. Well, if you're a widget maker, that's what you do for a living. And so most states I've seen, and I've looked at this in other states, I've actually litigated this issue in Michigan. Most states look at it and go, how reasonable are the limitations in time and distance, assuming there is one, and what's the industry? Because I can tell you, for instance, I've encountered this situation with somebody who was selling paint, industrial level sales of paint, like selling paint to automakers, for instance. automakers buy a lot of paint. Or, for instance, a radio disc jockey. A radio disc jockey. So when a radio disc jockey comes into court and says, Your Honor, I think it's inherently unfair, they told me that I cannot work within 75 miles of this radio station for 3 years. 3 years? 75 miles? How many other radio stations are there in North America, let alone in this state? Just they clearly want you out of this market for a little while. And by the way, that one makes sense because a radio station might hire somebody and along the way might decide to invest money in promoting that disc jockey in that market. I'm talking the old days. And so if they invest in you and turn you into the number one morning man, and then the competitor across town says, hey, we'll hire you, come over here right now, break your contract with them, come work for us right now, and you do that, the radio station just got snookered. They're the ones who made, partially helped make you a star by putting up billboards and TV ads and stuff. And so that makes sense. Now, they said you can't work as a disc jockey in America, in any of the 50 states, for 10 years. You go, okay, I can't practice my livelihood. So a court would strike that down. So if you are an employment lawyer, these are things you consider. Is how many other work opportunities are there out there for people like this? So we don't have a copy of the proprietary information, non-compete, non-solicitation, invention, assignment agreement that was signed by at least one of these men. We don't have a copy of that. So don't know what it says, but it'll come out in court. And a judge is going to look at that and go, okay, are these restrictions, are they reasonable? And they very well might be. And there was a very famous example of that guy who I believe left General Motors and went to Volkswagen. And GM got very upset because they say that he took with him a lot of inside information that General Motors had. Now, some people are going to say, but Steve, does Volkswagen really need anything GM has got? Well, they apparently wanted that guy. And GM claimed that when he left, he brought a whole bunch of stuff with him, which if it wasn't valuable, why did he take it if, in fact, he took it? And that became a mess. It became a mess. And that's the other weird thing about this is that if you start talking about high-ranking officials at companies that deal internationally with the making of sausage, how many companies are there? And it does start getting into fewer and fewer numbers, lower and lower numbers. But we'll see what happens. But as of right now, there's a lawsuit in federal court over the making of sausage. So again, in case you didn't catch the most recent issue of National Hog Farmer, thanks, John, for sending that to me. Ann Hess wrote that. Hormel files suit alleging former staff leaked sausage-making secrets to Johnsonville. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. For every action, there is an equal and opposite malfunction.